subcommittees that are meeting today. So we will, if anybody's waiting for a vote to happen today, we will be postponing the votes that are on the agenda. But we are going to go ahead and proceed with the rest of the agenda and dealing with the New Motor Vehicle Board and the California Recreational Trails Committee. There will be public comment after each entity, so if anyone's here for one or the other, you can take a break and come back, and we'll probably still address everyone else. I will wait until we have a few more folks here to talk about some updates on the bar pilot since the last hearing. And so we'll come back to that. But I do want to call up folks that are here for the New Motor Vehicle Board. We're going to do that portion first. So if our presenters can work their way up to the table, we're going to have William Brennan, the Executive Director of the New Motor Vehicle Board. Is he here yet? Oh, okay, great. Thanks. Peter Welch, the President of the California New Car Dealers Association. And then Ed Howard, Senior Counsel for the Center of Public Interest Law, is also going to be participating with this first panel. And I want to make sure that we thank the board for participating. And we worked with the California New Car Dealers Association and the consumer attorneys on a bipartisan consumer protection bill last year, AB 238. So we were somewhat familiar with some of the things that were happening. High-level review, the staff report recommends that the committee continue its operation because the board does provide an arbitration process paid for by the parties involved, which keeps the cases out of the state's overburdened court system, which we think is of significant value to the state. And certainly, given our current underfunded court system, it's particularly timely right now for us to look at things that continue to lower the burden on the court system. We do, however, the staff recommends that we look back at the board 10 years from now, given change in market conditions and changing practices that are happening with internet sales being a big piece of things that I know is a concern now for the car dealer industry, but it's certainly not at the point today that the committee thought that there was a need to get rid of the board. Market hasn't changed that dramatically, so for right now, that is the committee report's recommendation, but we certainly want to hear from the perspective of the board and the folks in the industry on how things are proceeding and how they see things developing over the next 10 years or whether they see any changes at all. I assume that everybody's had the opportunity to see the draft staff report. And with that and with welcoming, with welcoming Senator Correa, just in time, we're about to hear from some of our panelists now on their thoughts on the review process and things that they agree with or disagree with. So, gentlemen, we will go ahead and start with William Brennan, the Executive Director of the New Motor Vehicle Board. Hi.
Thank you. Thank you, Madam Chairperson, and members of the Joint Sunset Review Committee. Thank you for the opportunity to make a statement on behalf of the New Motor Vehicle Board. I'm Bill Brennan.
I am going to ask you to pull your mic a little closer to you, just so we can make sure we get you. Thanks.
Great. I'm Bill Brennan. I'm the Executive Director of the New Motor Vehicle Board. I've held this position since 2005. And I'd like to start off by commending the committee staff, particularly Mr. Malcolm McClatchin, for its report and recommendation that the board continue to serve the new motor vehicle industry. From the board's inception in 1967, your former legislative colleagues continually have expanded the jurisdiction of the board beyond cars and trucks. In 1973, they passed the Automobile Franchise Act, giving us our present jurisdiction. In 1975, they passed AB 507 or 509 to include motorcycles, franchisors, and franchisees. In 1982, they passed AB 2602 that brought franchised three-wheeled and four-wheeled vehicles under our jurisdiction. And most recently, in 2003, you passed Senate Bill 1948 that added recreational vehicles to our jurisdiction. The conclusion must be that we've been doing something right for these legislators to pass laws making the board's expertise and efficiency available to almost all members of the California motor vehicle industry. As I mentioned, we're pleased with the staff report recommending that we be continued. We also appreciate the finding that the board is fulfilling its duties as prescribed by law and that our stakeholders are largely satisfied with our performance. There are, however, certain areas in the report that need to be clarified or corrected. The committee needs to understand that the board truly has two distinct and different functions. One is case management, and the other is informal consumer mediation. The report seems to blend these two distinct operations and presents them as one activity in its narrative. In regards to case management, the board does not arbitrate or mediate disputes between automobile franchisors or automotive franchisors and franchisees, as stated in pages 5 and 10 of the report. Instead, in regards to case management matters, the board is a quasi-judicial forum that functions much like a court, charged with resolving disputes between franchisors and franchisees. There are three classes of disputes: protests, petitions, and appeals. Almost all functions filed by the court in the last decade have been protests involving franchisors and their franchisees. For example, this occurs when a franchisor seeks to terminate a franchise, or modify the franchise, or establish a new dealership, or relocate a dealership if there is already an existing franchisee of the same line make within 10 miles of the proposed new location. In this arena, the board exists to make certain that there is a level playing field and to protect the public's interest in having fair and reasonably available access to new motor vehicles, as well as parts and services. As a matter of fact, the constitutionality of this body of laws survived due process challenge in the United States Supreme Court. That's the Orrin W. Fox case. As mentioned earlier, the board does not arbitrate or mediate disputes. It adjudicates them much like a civil court, wherein the parties engage in discovery, file motions, participate in motion hearings, have pre-hearing, settlement, and pre-trial conferences. At merit hearings, the parties put on testimony with recipient witnesses and expert witnesses, introduce exhibits, and submit detailed pleadings and briefs. At issue are millions of dollars in terms of real property, inventories, and improvements. Businesses are at risk. The impact goes far beyond parties' losses. Businesses may be closed, people may lose jobs, and counties and cities may lose important tax revenues. On page 3 of your committee report, it recommends that the composition of the board members be reviewed. It should be noted that from 1977 to 1987, numerous court challenges were made regarding the voting and makeup of the board. Notably, in 1987, there have been no legal challenges to the composition of the board as it currently exists. That was involved the case of British Motor Car Distributors Ltd. doing business as Maserati Import Company versus the New Motor Vehicle Board. As constituted, the board provides stability, predictability to this critical industry. My recommendation to the committee is that the composition of the board remains unchanged so that history does not repeat itself with expensive and protracted litigation and ultimately adding government inefficiencies. The legislature should allow the industry to define its own terms because it knows best, and not assign the task to a policy committee that is unfamiliar with the nuances of the industry. Another observation of the committee's report that requires comment is that the board does not retain administrative law judges as mentioned on page 5. No one is retained by the board. Instead, the board hires ALJs who are all retired renewants that the board can call on from time to time to hear case matters. They are paid only as they are needed at an hourly rate paid to all retired annuitants similarly engaged. The board conducts periodic training classes, offers online training at the National Judicial College in Reno, Nevada, and as a result, industry disputes are adjudicated before knowledgeable ALJs allowing for predictable decisions that are based upon the evidence presented. The Board is also extremely successful in resolving disputes without the need of evidentiary hearings. In fact, 90 to 95% of all protests are resolved without engaging in adversarial hearings, thereby maintaining relations between the parties. This is essential to California's economy. The industry we serve is very large. We have over 1,800 new vehicle dealers or more within the Board's jurisdiction. There are approximately 333 licensed manufacturers and distributors within the Board's jurisdiction who sell everything from cars, motorcycles, ATVs, motor scooters, light, medium, and heavy-duty trucks, recreational vehicles, including trailers, buses, and low-speed vehicles. That sort of takes care of the case management side of the office. The other side of the office, which is distinct from the case management side of the office, is our informal mediation operation. This is a separate operation, as I said, informal because the program is entirely voluntary on part of the participants. The consumer, the dealer, the manufacturer, distributor. The Board has no enforcement authority, remarkably only armed with persuasion and the fact that we have trained and competent mediators. The Board has a success rate in excess of 70%. Just last year, mediators were able to document over $330,000 in consumer savings alone for goodwill repurchases, forgiveness of car payments, free extended warranties, refund options on contracts, and manufacturers agreeing to split repair costs for vehicles out of warranty. Our Board monitors this operation, but it does not hear or participate in its activities. This is an important no-cost-to-the-consumer public program which is paid for by fees charged to dealers and manufacturers and distributors and not the general fund. There is additional confusion in the committee report regarding the relationship between the Arbitration Certification Program and the Bureau of Automotive Repairs and the Board's mediation program and the possibility of overlapping responsibilities. The Board's mediation program provides informal mediation to consumers that have a warranty repair issue or purchasing problem with a licensed new motor vehicle dealer, vehicle manufacturer, or distributor. Unless a formal petition in the case management side of the office is filed by a consumer, an ALJ is not involved, nor is the Board involved as a body in the mediation program. And since 2005, 7 years ago, there's been only one consumer appeal or petition to the Board. You can interrupt me if you have a question. Okay.
I have a long list of them, so
Okay,
don't worry.
very good, very good. Okay. The Board does not resolve lemon law disputes. In fact, only a certified arbitration program provided by a car manufacturer distributor or the courts can resolve a lemon law question. It should be noted that the Department of Consumer Affairs Arbitration Certification Program does not help consumers directly. Instead, the program certifies and reviews third-party lemon law arbitration programs. As indicated earlier, there are currently 333 licensed vehicle manufacturers and distributors within the Board's jurisdiction. Of these entities, there are only 24 manufacturers with the certified arbitration programs, thereby leaving consumers without any recourse other than the courts when they have a dispute with the 309 other manufacturers or distributors. For example, some manufacturers you are familiar with that do not have programs include Chrysler, LLC, Mercedes-Benz of USA, Inc., and Subaru of America. The arbitration certification jurisdiction is limited to cars and trucks that are less than 10,000 pounds and the chassis portion of an RV. This leaves out of the other industries including motorcycles, ATVs, medium and heavy-duty trucks, motor scooters, buses, ambulances, and all parts of an RV except the chassis. That's a huge void to be filled by the courts if the new Motor Vehicle Board did not provide this service. Regarding the Bureau of Automotive Repair, there is no overlapping with the board's informal mediation program. The BAR is a very successful program that handles thousands of consumer complaints with licensed repair facilities. It focuses primarily on smog and automotive repair shops as well as body shops, and has no jurisdiction over consumer complaints with new car dealerships concerning contractual matters, nor does it have jurisdiction over vehicle manufacturers and distributors. The BAR deals with private pay repairs. The complaints filed with the board are limited to purchasing issues and warranty repairs, not private pay issues. Clearly, there is no conflict between the certification or the arbitration certification program or the BAR programs as suggested in the committee report. In conclusion, I'd like to remind the committee that the board does not exist to tell the industry what it must do in order to engage in commerce. The board exists to resolve disputes that arise in the franchise system and to protect the public's interest in having fair and reasonably available access to new motor vehicles as well as parts and service. The board is not a licensing agency or entity. It does not file accusations or otherwise initiate enforcement or disciplinary proceedings. The board is a quasi-judicial forum that decides very significant disputes that are brought before it. The legislative scheme and the board's expertise offer the industry the predictability of what will likely be decided by the board and what licensees need to do to be in compliance with various statutes within its jurisdiction. The new Motor Vehicle Board has done more to protect and improve franchisor relationships and reduce disputes than any regulatory scheme. Thank you for your time, and I'm available to answer any questions.
Thank you, and I want to thank Assemblymember Dickinson for being here. I have a lot of questions for you, but I think maybe it's better for us to hear from our other panelists first, if you don't mind staying and waiting, because I'd really like to know whether Peter Welch, the president of the California New Car Dealers Association, agrees with everything that was said by the executive director in terms of objections to the report, and any other comments that you might have. Thanks.
Thank you, Madam Chair, Assemblymember Dickerson, Senators Emerson and Correa. I am Peter Welch, and I'm the president of the California New Car Dealers Association. We're the statewide trade association that represents the interests of, I checked our database yesterday, it's 1,301. That's up almost 100 dealers from where we were a couple of years ago. I, too, want to thank the staff. This is a very complex industry, and it's a very complex set of codes for your staff and your members to go through. Some might even say arcane in some respects, but I think that over the years they have served the industry and the state quite well, and navigating the labyrinth of them is no easy job, but I think your staff did a very good job at doing that. I'd like to maybe start at the 50,000-foot level and then work our way down to the board and what this, not just the board, but what the Automotive Franchise Act does and how it protects the consuming public and, quite frankly, makes a wonderful transportation system for our state, which is very cost-effective. Not too long ago, 6-7 years ago, we had 1,700 franchise new car dealers throughout the state. The Great Recession left a huge mark on the industry, as it has on the rest of the state. We, from 1999 through 2007, sold pretty much between 1.8 and 2.2 million new cars a year, and somewhere between 1 million and 1.5 million used cars. We saw huge falls in those numbers. We hit the low point in 2009 when we only sold 1,038,000 new cars. That's more than a 50% reduction from a 10-year historic level when, of course, the population had continued to increase. Of course, our service facilities were filled to the brink because people weren't buying new cars. They couldn't afford used cars, quite frankly. So we did a lot of robust service on that. But yet we lost 346 dealerships during the last 4-year period. And that was thousands and thousands of jobs. It was literally tens of millions of dollars in state revenue in sales tax and vehicle license fees that we would normally collect. For instance, the average vehicle that is sold in I just picked Los Angeles because, as you know, the sales tax is different in each district. But the average price of a new car is about $32,000. That's $3,014 to the state every time we sell a new car in sales tax and VLF. And part of the sales tax goes to local jurisdictions, but of course that relieves you in your backfill obligations. We're on our way back. Last year we sold just under 1.3 million, so we're still 500,000 units off what we had been doing for a 10-year period. We did do last year, we did $74 billion in sales. Total dealership payrolls up to $5.8 billion. 117,000 Californians are employed by franchise new car dealers. We collected last year $6.3 billion, either collected or paid $6.3 billion in taxes. I just want everybody to be cognizant that this is like 10% of the retail economy. And we've got a finely honed set of franchise laws that have been, quite frankly, honed since 1973, almost 40 years back and forth. And we've got a new motor vehicle board with an annual budget of about $350,000 a year, which is paid entirely by new car dealers and automobile manufacturers. It's totally self-sufficient. And this little board, I like to think it's because there's 4 dealers on the board that run it so efficiently, even though they don't vote or decide any of the cases. They keep everything running very smoothly. I see Mr. Brennan nodding his head here because they serve on policy committees. This is internal policy committees and whatnot to make the thing run. So there's really 2 pillars of the whole system. And I'm talking about the franchise side. I'll make some minor comments on the mediation side. There's the Automotive Franchise Act, which is a combination of vehicle code licensing provisions and prohibitions that, quite frankly, level the playing field, make it unlawful, a variety of unlawful acts in the vehicle code. And then there's a provision that the board has jurisdiction over, and that's the so-called protest rights. And there's 4 or 5 of them. And quite frankly, I've always thought they're mischaracterized typically in the press. They're always talked as restrictive and that they limit competition. And quite frankly, none of that is true. All that it does is it gives a dealer a right, a due process right, to go before an administrative board and have somebody hear their case. There is a relevant market area, 10 miles. It only defines jurisdiction under which somebody has the right to ask for a hearing. So, for instance, if a manufacturer wants to terminate a dealer or if they want to add a new dealership in a certain location, they have to send a notice out. Dealer has 20 days, and that's it. If they don't file a protest, it's gone. The manufacturer can do whatever they want. If they do, they get to go before the board. As Mr. Brennan said, 95% of those cases are resolved through their process. And these types of disputes would otherwise be in court, although there's a unique set of statutes that set forth the rights of the dealers as they go through the process. Now, the unique thing about the board from my perspective is the hearing system. They've got, I believe it's 7 currently administrative law judges. Between those 7 ALJs, they have over 100 years of experience hearing just these types of cases. So it's the equivalent of going to court and getting a special master that has absolute expertise. I see you're nodding your head. I know you're a family law practitioner, but, it's not like, excuse me.
Just to correct, I've never practiced family law.
Okay.
Business litigation, actually.
Business litigation. I'm so sorry. But at any rate, how many times do you go to court and you get assigned to somebody that doesn't know anything about the case, and it's a bench trial, and you have to spend 3 weeks explaining, what it is, the jurisdiction. You don't have that problem here. And that's, quite frankly, in my opinion, one of the reasons they have such a high resolution, because you can cut right to the chase. They're highly specified and technical arguments on how many units are in operation and what's the demographics of the area. And this, of course, makes it different than your typical Article III court type of thing. This is an administrative body. And it's a quasi-judicial, as we say, because not only do they have expertise in this specific area, but they actually make public policy determinations that are typically not made in courts or within Article III purview, quite frankly. By statute, they are required to look at whether dealership locations, termination, and relocations will be beneficial or injurious to the public welfare and the public interest. And typically what they do is they look on a case-by-case basis and they say, do we need another dealership of this line make in this area because there aren't sufficient warranty stalls, service bays, parts, etc., or is the facility crummy and it needs to be replaced and this dealer needs to be replaced with somebody else, or that they're not doing well and they ought to be terminated? Quite frankly, in most cases where they're relocating, like 90% of the time, the manufacturer wins because they've done a study in advance showing that more people have moved in, there aren't enough service bays, it would be advantageous to the consuming public to put another dealership in. So they weigh all of those issues. That's something that judges don't have the authority because they're not administrative agencies charged by the legislature in making these determinations. So it's a very good balance. This is the fourth time in 17 years that I've done a review of the committee. As your staff noted, there was an LAO report in 1992. The Business Transportation Housing Agency did an extensive performance audit in 96. Of course, Governor Schwarzenegger's below up the boxes California Performance Review did an extensive deep dive in it. Each time, each one of those bodies came to the same conclusion, that once they understood what the board did and how cost-effective it was, they said, that this is a good deal going here. It's a good checks and balances and whatnot. So we would certainly concur with the preliminary recommendation that the board remain in existence. With respect to the composition of the board, I had mentioned earlier that we've got 4 dealer members that are appointed by the governor. They really serve administratively and act when the board members get together and don't decide cases. They can explain the industry to them. The 5 public members, who are the only ones that can determine any of the cases and deliberate on them, there are, of course, 3 of them are appointed by the governor. 1 of them is appointed by the speaker. 1 of them is appointed by the Senate Rules Committee, the pro tem. They have the discretion, obviously, to appoint whoever they want, whether they want the consumer advocates or whatever. We've seen a very diverse set of appointees over the years, quite frankly, that I think have served the board well. There's currently 2 Hispanic members. There's a former prosecutor, businessman, lawyer on it, and an African-American business person. And in another life, I've tried cases before the board. It's very effective. The heavy lifting is done by the administrative law judges that hear the evidence, and then the board does the final review. Now, with respect to the mediation program, unless there are any questions, but I guess we're reserving those till later, it's kind of small compared to the Bureau of Automotive Repair or the DCH or the Department of Consumer Affairs, but it's very effective. 80% resolution rate. I mean, I don't know very many mediation systems, and this is mediation as opposed to actually adjudication on the protest side. All that I can tell you is that in my career representing and working for car dealers, I've seen a ocean change in the behavior of dealerships with consumers. Right now, if you can't afford to lose a sale, you can't afford to have an alienated customer, and dealers bend over backwards when they can if they're aware of the problem. Some of them are manufacturer-oriented. If it's a lemon law case and we didn't manufacture the vehicle, it's not our obligation to buy it back. We have to sit there sort of with an angry customer and watch the food fight. But I can tell you, when a franchise new car dealer, and I'm sure it's the same way with the motorcycle dealers and the RV dealers, get a letter from the New Motor Vehicle Board on the New Motor Vehicle Board's letterhead saying there's a consumer with a problem, that gets on the desk of the dealer principal. And I believe that and that alone has a lot to do with the high resolution rate, because they generally like to take care of these issues when they find out about them. So we found it to be very effective. It serves a niche, and I'll certainly leave it up to the legislature to decide whether it can be improved. The only, I guess, last thing I'd like to say is I did have a little bit of difference, and maybe we can get into this with the questions later. The last sentence in here, that there's a proposed recommendation that Legislative Policy Committee is recommended to review the rationale behind the franchise laws in light of changing marketplace. I guess the only thing I can say is that in the last 16 years, we've been involved in at least 8 franchise bills, 6 of which were chaptered. Just 2 out of the last 3 years we did major bills that, quite frankly, each member of this committee voted in favor of. And it's not like it's a dead system that's sitting there that doesn't get reviewed, either because we introduce a bill or sometimes the manufacturers introduce a bill. I do believe there is a very robust, current, ongoing review of these laws, and there will continue to be, and that's healthy, quite frankly. Anyhow, I'll be happy to stay here and answer any questions.
Thank you so much. If there's, I'll break if there's burning questions of the members. Otherwise, we'll listen to our third person, that just to get this going, since we do have 2 boards that we're reviewing, or a board and a committee that we're reviewing today. So, yes, Ed Howard.
Good morning, Madam Chair, members. Ed Howard, Senior Counsel with the Center for Public Interest Law. The center, located at the University of San Diego School of Law, has for nearly 30 years studied California's regulatory agencies. It publishes the California Regulatory Law Reporter, and its staff have been appointed outside monitors for the Athletic Commission, the State Bar, and the Medical Board, among others. And thank you very much for inviting us to testify today. I think the reason why, as your background paper says, that both the LAO and the CPR initially recommended the elimination of this board is foreshadowed by some unanswered questions that I think will linger on the table and that I hope we'll be able to address in the hearing or in policy committee. But I think those questions do need to be addressed before you extend the life of this board for fully a decade, which is an eternity when it comes to the evolution of Internet and other kinds of marketing. So I'd also like to start at the 50,000-foot level, albeit very briefly. And that is to sort of note that government needs to be involved in the things that it needs to be involved in, truly needs to be involved in, but it should not be involved in the things it truly does not need to be involved in. And that is because, as a general matter, every regulation and every regulatory program involves a curb on individual liberty and higher costs, one way or another, directly or indirectly, to consumers, which, of course, in and of itself, higher costs is a form of restraint of liberty. Now, much of the time, maybe most of the time, those restraints and those costs are easily justified. But when doing legislative oversight, doing exactly the thing that you're doing right now, it's important not just to visit the operations of a government agency, but because government has no market competitor, it's important to revisit searchingly the underlying rationale for the existence of the program in the first instance, and to question whether or not, if it is to exist, it should exist in its present form. And that leads to a couple of questions that I think do need to be discussed. The first is, while the background paper accurately says that there is no general fund cost to the board, the implication there that there is no public cost, therefore, is unproven. Almost every fee that is imposed by government, one way or another, and to some extent, gets passed on to consumers. And in its effect on the ability of consumers to use that money to buy something else, it is indistinguishable from a tax. So the question here is the fee being passed on to consumers? If so, how does the consumer benefit? And is that benefit proportional to the cost that they shoulder? That is, as I say, especially pertinent, an especially pertinent question, given the authority cited in your background paper that says that the current system facilitated by this board might lead to prices that are up to 17% higher for this product than they otherwise might be. And what is the impact economically on the state and the general fund if the money that is 17% too high would be spent on other industries? I don't have answers to those questions, but those are exactly the kinds of questions that respectfully should be asked when deciding whether or not to extend a government program, especially for as long as a decade. The second is, are there other options that are less intrusive into private affairs that might accomplish much, if not the same objective, at a lower cost to consumers? For example, is there the possibility of state law requiring mandatory mediation in disputes before they end up at court? That would accomplish the savings objective in making sure that mediation exists or happens before you go to court without necessarily creating a government agency. There are other nonprofit examples and other examples and alternatives possible as well, but the question about whether or not there are alternatives is something that should be on the table. Modestly but operationally, the background paper talks about how 14% of consumers were not satisfied with the mediation process. That's a small number and potentially indicative of satisfaction for the overall program. But more importantly, the question should be asked, the footnote in your background paper indicates that the board was not able to expand upon that number and explain why it existed. If that's true, I think we want to know why the board was not able to expand upon why those 14% were dissatisfied. And finally, it's come to our attention that the board has, and this is not in the background paper, but the board has authority to overrule the Department of Motor Vehicles when it comes to consumer issues. And I think we need to ask what public policy warrants giving the board, whose primary mission is the protection of car dealers, the power to overrule the Department of Motor Vehicles in consumer cases. Why is that private interest elevated over the consuming public one? Is that justified? And what are the benefits to the consumers who we think, in all likelihood, are probably paying the lion's share, if not all, of this program? So in conclusion, thank you for your time. It is worthwhile observing that a small minority of states, according to the background paper, have this particular program, that prior reviews suggested eliminating the board, and that 10 years, as I said, is a very, very long time when it comes to the evolution of commerce over the Internet. And with that, I'm happy to answer. Thank you again, and happy to answer any questions you may have.
Thank you. And I'm actually very proud that we have a panel that has diverse views. I think that's a good reflection of the review process. I do have a couple questions if other members don't yet. And actually, I'd like to focus a little on, Mr. Brennan, your comments, because one of the suggestions that you made was that a policy committee should not review the composition of the board and the input that goes into the board, primarily because, as I wrote it, they're uninformed about the industry. And I guess my concern with your comment is this kind of hands-off legislature, you shouldn't be looking at what we're doing kind of message by saying policy committees should not look at, because I don't take exception to Mr. Welch's comment that there are policy committees looking at the franchise laws now, and so it really is a vigorous reform process, and I thank you for your input on that. I think that's helpful. But I'm a little concerned about your comment, Mr. Brennan, that policy committees who are uninformed about the industry should stay uninformed and not look at it.
Well, you misunderstood my comment. What I said was that this issue had been reviewed and had been subject to court challenge during a 10-year period. And in that 10-year period, there were numerous court actions in which this very issue of the composition of the board and makeup of the board was adjudicated. The final resolution was the composition of the board as it now exists. I am just advising the committee that rather than expose the board, the industry, to potentially another 10 years of or extended period of time of review and litigation and adjudication over the composition of the board, I'm merely saying that it hasn't been challenged in the last, since 1987. That's, almost 20 years of the industry and the people that appear before our board pleased or at least acknowledging the composition as it now exists. And I'm just suggesting to the board to review it might open the door again to extended litigation and court cases in regards to the composition of the board. And I'm just saying, leave sleeping dogs lie. This is not a big issue, and I'm not saying that you shouldn't be reviewing this stuff. I'm saying before you do, understand that it has gone through extensive court review, and in my mind's eye, there are other things that the committee maybe should be focused on.
Okay, thank you. My take on that is that that's a great argument to be made before a policy committee, but since we're not looking at the policy, but rather the efficiency and effectiveness of the existing board, I think we just include that in the report so that any policy committee is fully aware of all of the litigation and certainly knows the risk to the industry of changing the composition before it's done. But I see Senator Correa has a question.
Thank you, Madam Chair. And I'd just like to say that over my tenure in this legislature, it has been a policy to review the composition of these boards. And I believe that part of the reason you want to review the composition of these boards, I believe, is that their mission, which is consumer protection in many ways. Not only is it regulating of an industry, but also to look at consumer protection. And I believe there's a lot to be said to have non-industry individuals within boards. I also concur with the perspective that 10 years for the next sunset review is just too long. I believe a shorter time period it has merit, because that is our job as a legislature, to review what is going on, whether you're, industry or non-industry. There's a lot of changes that will happen in a decade. Anyway, those are some of my perspectives.
Senator Correa, I happen to agree with you. I'm going to defer to the policy of the committee with respect to the sunset review process. We actually don't like the process. We don't think you should, in advance, set effectively a death sentence, and then, in advance of having hearing. This is the fourth time.
Can I interrupt you? What do you mean by death sentence? Explain to me.
Well, the process that the committee, and I'll respect the committee's position, that they want to, enact sunset statutes and put it into a bill saying that, by statute, a board or commission, any board or commission, not just this board or commission,
sunsets,
is going to be repealed in a certain date, unless something else happens. We think that it's more efficient and more proper to, if there's a problem, review it. Quite frankly, I'm prepared to come to any legislative body any day, any year, and defend this board. This board does a great job. Okay, I think it's one of the boards that you should use as an example to other industries and others on how effectively and cost effectively it works. And we're here year in, year out. We're not strangers. I might take a little difference with Mr. Brennan on this issue. I mean, this board's created by the legislature. You ultimately set the policy. If you want to change the composition, it's your prerogative. We will be there with bells on our toes with suggestions on how it's properly constituted, and we'll defer to the decisions of the legislature on how it's composed. We have been doing it. It's been honed over the years. We think it's working pretty well right now. Are there room for improvement? There's always room for improvement, and we would like to participate in that process.
And through the chair, if I can, Mr. Welch, is, this has been the debate that we've had when we look at other boards, medical board, any other specialty boards that, the argument is we need experts. We don't want those folks that don't know about our business, but that's exactly why we want those folks from an outside perspective to add to the discussion. And in terms of your comment of a death sentence, as you said, the legislature created these boards and bureaus, and there's a reason to put those sunsets there, and that is to come back and review whether the process is working or not. So, and most of the time, as you see, most of the time, these boards and bureaus are actually permitted to move ahead. So I don't believe you can characterize it as a death sentence. I think it's more of a review for the goal that you create these boards and bureaus, which is consumer protection and regulation.
Again, Senator, we don't have any problem, any objection to reviews anytime. It's certainly within your prerogative. And you know what? When we're done with one of these reviews, the commission, or in this instance, the New Motor Vehicle Board, is always stronger and better and learns things and can employ those and implement them go forward. And then there's typically ideas that evolve from these hearings that result in proposed legislation. And we don't have a problem with that. It's all part of the process.
I do want to take a moment to reflect on your comment, because big picture for Sunset Review process is we are looking for models and we are looking for things that work. And I have to say that this board is being incredibly efficient with the money that is spent. I have to take issue a little bit with what Mr. Howard said. To have a budget of $350,000 to $400,000, deal with the volume of disputes and the volume of property at stake, just in the market share value of the rights that are being negotiated in protests, for example, and I use negotiated loosely, adjudicated if I am to use Mr. Brennan's term, and hires 7 administrative law judges included in that budget. I do think that there's cost savings, because those are disputes that would be in our courts, that would be more expensive for the parties involved, that would then be pushed on to the consumers in a more expensive venue. So I do think that there is still value. That's why the committee's recommendation is that we continue with this board as it currently stands, but continue to review, because certainly other states are responding in different ways. We have, the report refers to some of the instances in Texas where we have a California manufacturer/dealer trying to do business in Texas and having problems because of the way they're set up. So the report's recommendation that we look again at the board is because of changing market conditions and the necessity. If we go from the 1,301 dealers that we have now to 400 dealers 10 years from now, certainly there would be an argument that maybe this is not the best way to deal with the remaining number of dealers that we have. We've lost a lot in the last 4 years. Whether or not the next 4 years would change the market so dramatically, the legislature can always pull the board up for review again. And I think the idea is, for the Sunset Review Committee, we have so much of the overall government structure to review, and I've often cited Texas as an example. It takes them 12 years to go through their entire government structure in one committee. That it is very difficult to say in California, where we're so much larger, that we're going to be able to review more quickly. The policy committees can review in any given year. I just want to suggest that the 10-year time frame was really kind of a balancing between the changing of market conditions and the workload of this committee to get through the entire government, but in no way meant to say don't look for 10 years, because certainly any policy committee can look at any time over this issue. But
Through the chair, let me just finish my thought if I can. And that is that in no way is this, anybody saying you're not doing a good job. It sounds like you are doing a very good job, but I think it's just an issue of the policy and how you review these issues. Ultimately, there's a reason why boards and bureaus are created, and that is to make you independent of the state bureaucracy, so to speak, because the concept is you and the industry have a different perspective, a better perspective maybe, to self-regulate. And that is essentially the way I interpret, and it is why you probably get a vote to not have a death sentence upon you, but to continue to operate in that same framework. You do it not every 10 years, but maybe every 5 years or every 3 years, the way other boards and bureaus. My goal as a policymaker here, and the next few years that I have left, is to make sure that what has happened with other boards, who I will not mention, happens. Which is a lot of those really go off, then you got to pull them back. You got to fire effectively everybody on the boards and reconstitute and sunset them. I think you're probably a stellar example of self-regulation, but I think for the legislature there is value in us saying, hey, how you doing? You doing a good job? Move on. Next.
I think, if I may, Madam Chair, the Sunset Review is not punishment, and legislative oversight is not punishment. It's really, in many ways, what this legislature should be doing respectfully more of, and a more thorough job all of the time, every time. The burden on when a government program is created, it doesn't have an ongoing entitlement to exist. In fact, most government programs ought to have as a part of their core mission their own future obsolescence. So it's not punishment, it is an effort to make sure that the underlying purpose for which the program was originally created still exists, that there aren't alternatives that have evolved in the meantime that might be equally efficacious and less invasive in the private sector. And it's a way of potentially identifying reforms that improve the performance of the entity, even if it decides to endure. On that last point, just to clarify, I apologize if my testimony gave the impression that I said that there aren't savings here. I think that there probably pretty clearly are. But there are questions about cost versus benefits of those savings, and whether or not there are other alternatives, other ways of achieving those savings that might not result in fees being passed on to consumers and might be less distorting of the underlying market. So it's a question of alternatives, Madam Chair, not necessarily about whether or not there's savings or not.
Thank you. And Mr. Brennan, is it possible for us to get a copy of your testimony today? Thank you. I think that would be very helpful as we look back at the report and clarify some of the things that may have been kind of confusing or misleading. I certainly don't. That's not the intention of the committee report. And if you wouldn't mind working with the committee for us to finish the work on that report so that we can have something that can kind of carry beyond the life of this committee for folks to look back at.
We'll gladly do that. And I agree with the comments. We fully cooperated with your staff, and we will continue to do so. And we're not playing hide the thimble at all.
Great. Thank you very much. Senator Emerson.
I do have a question on how the new motor vehicle board is funded. Is it fees of franchise, motor vehicle franchises? Is that who pays for the?
We have two funding sources, primary funding sources. One, for every vehicle sold by a manufacturer in the state of California, we receive a set fee. And each dealer, when they pay their renewal of their license, for their dealership license, we also receive a fee for that. So we receive fees from both the dealer side and the manufacturer side that funds our operation.
Thank you very much. We're going to transition to, I'm sorry, Assemblymember Dickinson.
No problem. Thank you, Madam Chair. I've got a couple of thoughts about the exchanges so far and an issue or two I want to explore that we really haven't talked about so far this morning. And I would just say, with respect to the composition of the board, I think what the courts have told us primarily is what we can't do. They have not necessarily defined the limits of what we can do, and I think composition is a worthy subject for review, but it's also tied to what the mission of the board is. And by the way, I should say I think this board ought to remain in existence. I think it does today and can in the future continue to perform a valuable and useful function, primarily, in my view, for the manufacturers and the franchisees, and in more limited way for consumers by extension. But I'll come back to that in a moment. I appreciate the characterization of sunsetting boards as a death sentence, but it's as much in discipline for us as it is for any other purpose if we think we're going to come back and review things on a periodic basis without being forced to. I think history teaches us that that's less likely to happen than if there's a sunset date. So it has I think a practical effect of making sure that we look at various subjects, whether it's legislation or boards and bureaus, agencies on a periodic basis. The issue for me is, I think, more the mission of the new Motor Vehicle Board, which of course had its origins in trying to resolve disputes between manufacturers and franchisees. And to the extent that that's the mission of the board, dealer members of the board, albeit less than a majority to me, makes sense. When we talk about the mission, which in more recent years has expanded to including some attempt to resolve consumer disputes, then the question of whether the current composition of the board makes sense, even with dealer members not participating in those decisions, I think is much more a question that needs to be addressed, and whether if this is part of the mission that continues, ought to be totally a public member board. I appreciated the comment that you made, Mr. Welch, in the course of your testimony, that the dealer members help educate the public members on how the business works. There's nothing wrong with the public members being educated. I think the question is, should they be educated by their colleagues sitting at the same dais with them, as opposed to dealers who offer their testimony just as a consumer or anyone else might offer their testimony or thoughts about how the business operates and what makes sense in the context of whatever the issue is before the board. I do not believe, as this board is currently constituted and the way it operates, that it is necessarily the best paradigm for resolution of consumer disputes. I see a satisfaction rate on the mediation of more in the 60% territory than the 80% that you referred to. But I would also suggest to you from a few years of my own experience that you have to delve into what satisfaction means in this context. Oftentimes it means to a consumer, that's the best I can do because I can't afford to go any further or in a different direction to try to resolve this dispute. So I will live with the outcome. I'm taken by the suggestion that we review on a policy committee level whether consumer disputes ought to be handled by another agency, although the Bureau of Auto Repair is probably not where I would tend to go, because I think BAR has a different and more precise focus. But I would invite comment. I would invite comment from any of the three of you on why this board should continue to be a forum for the resolution of consumer auto disputes, and why it ought not to move to a different agency, whether it's the Department of Consumer Affairs with some additional authority, or some other agency.
I'd be happy to respond to that,
Sure.
Assembly Member. First of all, with respect to the composition of the board, I do have some familiarity with the Texas model, and quite frankly, there are several other states where dealers that used to, in fact, some of the states, dealers actually vote on the cases, and their Supreme Court said that they're not biased tribunals. Our Supreme Court said it was a biased tribunal. Some of the response to that was, well, we stick a manufacturer representative on there, it'll become unbiased. And several states have said, no, it just makes it more biased. You really need, and that's why, and we agree 100% that the public members and the public members alone ought to adjudicate the disputes. I'll certainly defer to the legislature, and if you think there's a better way to do it, again, there's no restrictions whatsoever on the appointing authorities. Our only concern is if you get 7 or 8 or 10 or something members on it, then you get quorum problems, and it's more expensive and whatnot. So, but we'll certainly defer. With respect to the mediation program, I think it's important to note that the board itself does not mediate cases. It's done on the staff level. To my knowledge, there's never, ever been a case that's gone before the public or dealer members of the board for mediation. The staff hires mediators. They have law students. They have professional mediators, and it's done on that level. They never go up to the board for a vote. They don't have a mandate to enforce anything. It's mediation. It's not arbitration. It's not adjudication. So I think that's an important distinction. And again, I'll defer to the legislature with respect to whether the legislature believes that there ought to be some, state-run mediation program for anybody that buys a new or used vehicle. I will point out, which is pointed out in the report, that the board doesn't have jurisdiction over used cars, so it is a niche that they do. And I'd also say that if you want to make it much more robust, it's going to be a bigger board. We're going to have to get more funding and whatnot. But those are all great policy issues that could and probably will be discussed.
Well, just two quick reactions. One is a staff works for an executive director that works for a board. The message of the priorities of that agency, I think, most often do extend down to the staff. And perhaps some different approach to mediation, actually, although it would seem to cost more, would cost less if we kept things out of courtrooms. But that's a good subject for further discussion. The one other area I wanted to, I'm sorry, Ms. Brennan, did you want to make a comment?
On that I did.
Yeah.
And I just, to say that in my opening statement, I tried to distinguish between the two operations of the board. We have the case management side, which involves our board. On the mediation side, as Mr. Welch explained, the board doesn't get itself involved in that. It oversees, and you're correct, they oversee through me the mediation activity. But never has the board been involved in any of the mediation decisions that have come out or that our mediators have been involved in. We report to the board our success rate, our failure rate, whatever, on a periodic basis. And beyond that, the board doesn't get involved on the mediation side of the board's activities.
I want to move to Senator Correa first, just in case that this dialogue can also answer his question.
Oh, I had one other area. I'm sorry, if I may. Thank you for your indulgence. I'm curious about whether there's any place else in state government where a board gets to review and overturn potentially the administrative decision of the agency.
Of another agency.
Some other department or board where that power exists or that prerogative exists in state government. Are you aware of any?
No, I'm not aware of any.
This is another area I think needs to be included in the review. I honestly do not understand why. And that's why I was asking whether there are any parallel situations. I don't understand why the new motor vehicle board would be empowered to review administrative decisions of the Department of Motor Vehicles, particularly as it relates to the conduct of a manufacturer or a dealer, and overturn those. I would be interested if there's precedent for that in any other field. I'd be interested in the explanation of a justification for that process.
Well, I can, again, Peter Welch,
Yes.
to respond. I mean, historically, I think it's about once every 5 years that a case percolates up there, a disciplinary case. I would like to correct something that was said earlier. The board has no jurisdiction whatsoever to overturn consumer complaints. These would be disciplinary actions brought by the department against a licensee, either a new motor vehicle dealer or a manufacturer. And yes, it does have the authority to review those decisions. And quite frankly, it's a check and balance type of issue. You have to understand that the department licenses the manufacturers and the dealers. The department, unlike other agencies, has its own effective police investigators that investigate it. They have their in-house legal department prosecutes the case before ALJs that exclusively are assigned cases, and then the director gets to review that. It's all done. And I might add, the way the statutes are written, the new motor vehicle board is a department within the DMV. It's not in its staff, their payroll, but it's a board within the Department of Motor Vehicles. So it is part of that whole process, and it's checks and balances.
It is unprecedented as far as I know. And the fact that it is a disciplinary matter doesn't make it any more or less a consumer issue. Typically, it is also the case with the other licensing boards, whether it's the State Bar or whether it's the Department of Consumer Affairs boards, that the process is identical. A complaint comes in, the agency charged with issuing the license is the agency that is charged with investigating it. Very frequently, those are actual peace officer investigators. It proceeds to an executive officer who determines whether or not there's a sufficient ground, and usually, hopefully, in consultation with counsel for an accusation. An accusation is issued, an ALJ issues a decision. The ALJ's decision is a recommended decision, always, and the agency has final say. So I'm not aware not only of a question of one agency being able to override another. I'm certainly fairly confident in saying that a board within a broader agency doesn't have the authority to override the disciplinary decisions of the broader agency.
One last comment, if I may. All of these decisions are subject to administrative writ of mandamus. In fact, the last time that the board overruled the department did file a writ of mandamus, and the Court of Appeals smacked down the department and agreed with the board. So, I mean, there are checks and balances all the way up, and the board is not the final authority; it's the courts.
I know we've got another matter to deal. I don't want to prolong this. I would suggest that this is an appropriate topic for review as some broader review of the board goes on, consistent with the recommendation.
Thank you, and we will
Thank you all.
include that part in the report. Senator Correa.
No, I concur that like to look at that issue, but also wanted to, Mr. Peter Welch, you said that you don't have any jurisdiction over the used car area. Any thoughts on that, one way or the other? Is that a good thing or a bad thing?
Well, again, the Franchise Act only applies to franchisees, so that's why the board was created primarily to exclusively, quite frankly, to hear protest rights that only apply to franchisor franchisees. Obviously, used car dealers don't have franchises to sell used cars, so there was no regulatory scheme included in the enabling statutes. So because their jurisdiction is exclusively limited to new cars, when it comes to the mediation issue, they don't have jurisdiction over that either. Now, I guess if a new car dealer sold a used car, they have jurisdiction over the licensee, but not used car dealer licensees.
Thank you.
Thank you very much. As always, I find that these reviews educate the current members of the legislature on things that we don't look at every day. So I appreciate very much everyone taking the time to come here. We're going to go ahead and switch to the California Recreational Trails Committee and ask, I'm going to butcher some names here. Actually, I almost forgot. We were going to do public comment for the new motor vehicle board, and I just want to make sure that we provide the opportunity for folks to comment on what was said today and what the report is on the new motor vehicle board. Is there anybody here to comment on that? Thank you.
Madam Chair and committee members, thank you for inviting me to make a presentation. I'm John Palavoda, the Executive Director of the California Motorcycle Dealers Association. And we're a 41-year-old trade association for California's franchise motorcycle dealers, not used motorcycle dealers. Again, the franchise issue is what we're about here. Over 300 dealers in California look to the CMDA to represent their legislative and business interests. On behalf of our board of directors and members, I'm here today to offer our unconditional support for the continuance of the new motor vehicle board. That doesn't mean that should proposals come up from the legislature through this review that we wouldn't want to respond to that and perhaps support any of the provisions that came up here today or suggestions that came up here today. But the fact is that the new motor vehicle board, we support the continuance of the board, but without the sunset that has been suggested here. We feel that the inclusion of the sunset, no matter how long, how far out it is, which is 10 years, has a tendency to dilute the important work that it provides to the state. And over the last few years, I've been doing this for about 15 years now for representing the Motorcycle Dealer Association, and from time to time we have introduced legislation to include the new motor vehicle board in various areas of the franchise law that it doesn't have jurisdiction over. And it's my personal sense that if a sunset is established on this board, then members may, and I don't want to speak for anybody, but my sense is that when legislation is introduced, members may feel that, well, it's going to sunset anyway, so really why should we be changing this any? And getting back to the sunset again, I have a whole dissertation here, but I agree with everything that's been said, and I don't want to duplicate the things that have been said about this, and I don't intend to. I just wanted to concentrate a little bit on the sunset, and the fact is that the legislature, I found in my 15 years, can call for reviews of anything it wants to, and if there's a composition problem, if there's a mediation problem, or any of the issues that might arise, you don't have to wait for a sunset to review it. A legislator can introduce a bill, and those issues can be taken up and reviewed and voted on, and you don't have to wait basically for a sunset. So that's my rationale for suggesting that perhaps we don't include a sunset on here. And again, I think we also get down to the cost issue. I know this committee is going to review an awful lot of other boards, agencies, committees, and what have you, and I don't know how many of them are not going to cost the state anything. And this board, for all the good that it does, for, as you had stated, for the amount of income to the state, what it represents as far as sales income to the state, and the cash flow that comes to it, to the Treasury, for the amount of money it costs, that it costs to operate it, and that in turn doesn't cost the state anything, we feel it's an incredible benefit, and certainly it benefits the motorcycle dealers. We are a small part compared to the total picture, but nevertheless, we've been in here since 1976 and continue to support it. So thank you very much for allowing this presentation.
Thank you. Thank you for your time.
Good morning, and thank you for allowing me to appear. I'm John Sims. I'm a professor of law at the University of the Pacific, McGeorge School of Law. And before I started teaching at McGeorge, which was in 1986, I'd worked for 11 years for the public interest law firm founded by Ralph Nader called the Public Citizen Litigation Group. So I handled a lot of consumer cases and administrative law matters there. At McGeorge, I've taught a number of classes that are pertinent to the discussion today. I've taught administrative law a number of times. I also taught remedies. So I'm appearing today on my own behalf as basically a consumer advocate and somebody who's spent a lot of time looking at administrative processes. And I'm also here on behalf of the Consumers for Auto Reliability and Safety. Now, you probably remember that's the group that Rosemary Shahan is the president of, and over a long period of time, she's been one of the most informed and most persistent advocates for consumers and looking out for their interests, guarding against fraud, and promoting auto safety. So I'd like to focus just on one aspect of the discussion today, which has been fairly wide-ranging, and that does relate to the issue that was brought up a couple of times, and Mr. Dickinson referred to it specifically, which is what I think is really an anomalous aspect of the jurisdiction of the board, which is that power to simply sit in really a quasi-appellate role and overturn a decision made by the Department of Motor Vehicles. And that, it is organizationally odd because the board is itself part of the Department of Motor Vehicles. So I certainly would concur with the comments that particular arrangement is unique as far as I know. But it also really takes the board away from its mission and asks it to do something it's, I think, not particularly well qualified to do, and I think not particularly well interested, not really that interested in doing. That is, the board exists to protect the interests of the dealers, and we've heard testimony that it does that effectively, but it doesn't really see itself, it's never seen itself as primarily a direct protector of consumers, except through that whatever indirect benefits they get from the whole regulatory system. And so therefore, for example, there was a lemon law case some years ago where the DMV had found that there had been egregious, widespread violations by Chrysler that was going to lead to a temporary suspension of its license. The board overturned that, and it ultimately ended up in court anyway, but the board was really forthright in saying our job is to protect the dealers and this industry, not consumers. And so it's not that much of a shock that they haven't protected consumers particularly well. So what I would suggest would be easy to do administratively as part of the sunset process would be to take out that one relatively small and really anomalous and poorly implemented aspect of the jurisdiction of the board, and leave the consumer protection to the DMV in its limited responsibilities with regard to these disciplinary matters, and let the courts play their roles, let the other consumer protection agencies play their roles, but take away from the board the ability to just step in and reverse a decision that's made by the Department of Motor Vehicles with regard to consumer protection. Thank you.
Thank you very much.
Briefly, Skip Dahm on behalf of the California RV Dealers Association. It was our bill that put the RV industry into the jurisdiction of the new Motor Vehicle Board for two very important reasons. It is very efficacious, and it avoids dealers perhaps having to hire an attorney in Georgia or Indiana to settle disputes between a franchisor and a franchisee. That alone makes it very worthwhile to us. I do want to associate all our opinions on this with the comments made by Mr. Welch. It's very appropriate, it's very similar, and I think that the true benefit of the board insofar as the RV industry is concerned is that it really does level the playing field, whereas historically it has not been level, and we're very pleased with it. The amount of cases, several dozen that have come forward since, have proven to be worthwhile to both parties, and therefore we support the continuation of the board. Thank you very much.
Thank you. Seeing no further public comment, we will now move to the second part of our hearing, the California Recreational Trails Committee, and if we can have all of our speakers for this one here. The staff report does recommend sunsetting the Recreational Trails Committee because many of its statutory duties are no longer necessary or being handled by other entities. The Parks and Recreation Department's decision to disband the Recreational Trails Committee is reasonable in light of our current budget circumstances. Now, this is not without prejudice to it coming back at a time where the needs are greater and budget constraints are less. But in our current circumstances and environment, we find that the Recreational Trails Committee is not as necessary as it once was with its original mission. So this is the first committee we've actually recommended sunsetting. So you're in uncharted territories here, but we have, actually I'll let you go ahead and introduce yourselves just in the interest of time. Go ahead.
Okay.
Yeah.
I'll go ahead and start, John. Thank you, Chair Huber and committee members. My name is Steve Musalami. I am the chair of the Planning Division, the chief of the Planning Division. You're the chair. You're the chair for California State Parks. And we have been in the role of we've held the role of the managing and being the staff for this committee for basically over 40 years. So it's been a very long-standing committee. And what we've found over the years is that the language in the statutory language was developed 40 years ago. Things have significantly changed over the years, and we do believe that there are very few of those language items are addressed now by the board or by the committee, and that doesn't mean that there isn't a value to the committee. Our biggest issue right now is that we are facing significant budget cuts, as you all well know, and the planning division that I manage is having a 50% cut in staff. So it's significant. So what, now do you want me to go ahead with my presentation? Okay. So again, the committee was formed in 1968, and it was formed to basically support the California Riding and Hiking Trail, which was a plan for a long statewide trail across the entire state prior to the Pacific Crest Trail.
It was then converted to the California Recreational Trail Committee with a little different focus, focusing more on establishing a statewide trail plan, which would integrate many local regional trail systems. The committee also has been involved in establishing the Trails Report, the statewide Trails Plan, which started, the first plan was created in 1978. We've updated that plan in 2002, and we've had progress reports in 2009 and 2011. Again, that's mostly all of our staff time working with the committee members to generate those. The committee is also very influential in establishing the California Trails and Greenways Conference and Training that occurs annually within the California. That was established in 1984, so we're in 27th year of that very important element of linking many of the trail community in California together. It's the only trail conference or only ability for all of the trail users to come to one location and to get trained on what's happening and share trail knowledge. Also, the committee was involved in endorsing the California Trail Days program, and that was also a governor-endorsed program for many years, which allows people to get together and work on trail projects and basically get connected again with trails once a year. So the reason that we actually are recommending the sunsetting or following through with the sunsetting is mostly fiscal. We do believe there's a value. We are just at a point where we have to really see what our core functions are as a department and where we actually have time to spend with our staff. There are many of the statutes, and we were asked to kind of explain why we recommended the sunset and why we and how we can kind of carry through what a lot of things that this committee does. So, for example, the committee is involved in coordinating trail planning among cities, counties, and districts, and many of those today are done by the local entities. The local trail communities in different regions of the states and different cities and counties have established now many of their own trail organizations that have supported what's happened and how trails have been developed in their areas. In the 60s, those didn't exist, which is why the Trail Committee was very important at that time. Also, they coordinate and have the statutes actually identify that the committee would help develop standards for trail construction. And again, back in the 60s, there weren't a lot of standards for that. Today, there are, and they have been developed in coordination with the committee and our department, along with the Forest Service and the Mountain Biking Association and the American Trails community. So there's been a lot of standards that are out there now that we're continuing with. Again, mentioning that we're tasked with maintaining the recreational trail plan. We've continued to do that over the years. That's mostly a staff effort. We do utilize the committee for meetings to basically publicly vet the plan and get input on the plan. And the last item is private property trail issues. And again, those are really handled now at a local level as opposed to a statewide level, which at that point it was more geared towards the riding and hiking trail. So roughly we spend approximately $50,000 a year of our department dollars to support conducting the meetings. We've had in the past had typically quarterly meetings. The past couple of years, because of budget cuts, we've had to cut those down to one, which is basically at the trail conference that we've been holding those. That pretty much concludes my presentation. If you have any questions, I'm available.
Great, thank you. Well, now we'll hear from the chair.
Thank you, Chair Huber and committee members. I'm John Mercurio. I'm current chair of the California Recreational Trails Committee, and I'm asking that our committee be maintained because it provides benefits that no other state park entity provides. It is very inexpensive, and there's actually a better solution than Sunset, we believe. The California Recreational Trails Committee, which committee members simply call the CRTC, has been around for a long time, as Steve said, and at least for the 10-plus years that I've served, it has played a number of worthwhile roles serving the trail community in California. This community, the trail community, is made up of primarily of equestrians, hikers, runners, mountain bicyclists, and as you're probably aware, its 7 members are appointed to represent all geographic regions of California. We have 2 from the south, 2 from the north, and 2 from the central California, and then 1 at large anywhere in California. And we don't receive any compensation for our service. Members also represent the various user groups. We have 2 who are primarily equestrians, 1 who is a mountain biker, 1 who is a hiker and very familiar with the Pacific Crest Trail and its support organization. Another is a hiker backpacker, and the remaining 2 are associated with more than one group, and I'm a member of that group. I consider myself a hiker, runner, mountain biker, inline skater, and until recently a stroller pusher. And I have to say that pushing a stroller got me to understand the obstacles that still remain to wheeled vehicles on trails and sidewalks. So I feel like I'm like an ADA advocate now because I had to go through all that. So I'm glad I did it, and it's opened up my mind to all this. And there's another dimension to the committee membership, and that is the various roles they play in their respective lives related to trails. Regarding the existing members, we have 1 that has held elective office, City Council, 1 that is a full-time trails professional in her county, 1 that is active in a major nonprofit mountain biking organization, and 1 that has extensive experience mediating trail use conflicts among various users. And I have a number of applicable associations, including service on the East Bay Regional Park District's Park Advisory Committee for about 10 years, and serving on the board of a large regional land trust, working for the last 25 years or so on numerous trail construction and maintenance projects, and serving on the Planning Commission in my city. So I guess I'm a joiner. As chair of the committee, I would like to make several points that support the notion that the CRTC should not be eliminated. Perhaps the greatest benefit is that the committee can advise state parks and provide assistance to local agencies on the needs of California non-motorized trail users. The committee is the only place the public can provide input on a statewide level. And as I just outlined, the committee's composition reflects geographic and trail user group diversity and is an entity that has not existed otherwise. It's a tremendous asset to state parks, the political system, and the public. As an avenue for public involvement in trail planning and trail use issues, it has been active. The CRTC has always taken an active role in the preparation of the California Recreational Trails Plan. Again, Steve mentioned that. This mandated document is written by state park staff with input by the public, but the CRTC kind of acts like a facilitator when we have those meetings, and then we review the document, and there's always lots of input from the committee members. We all have our little areas of experience, and we contribute to the statewide plan. And then there's the California Trails and Greenways Conference, which is held once a year, alternating between Northern and Southern California, and it is organized by a nonprofit created expressly for this purpose, but with the help of the state park staff. Members of the CRTC take an active role in both the planning and staging of this event, attended by hundreds of trail users, advocates, and professionals each year. Last year it was held in my area, in my county, and so I can tell you that I put in a lot of hours helping with that. It was really fun, and it was nice to see it all come off great. I mean, everybody worked together really well, but the committee members really contributed a lot of their time to it. The way it generally works is, if it's in your area, you're like tagged, and so you get to help out even more, and I really enjoyed it. The CRTC meets no more than 4 times a year. For the past several years, it's met less frequently than that. And at these meetings, which are generally well attended, the public is provided an opportunity to present their local trail issues to an official body. the fact that the members, we're appointed by the governor, lend stature to the committee, as well as each committee member's own knowledge and experience in the trail world. Oftentimes, the committee members and staff are able to offer suggestions to help alleviate problems in the area. Another element of some of the local meetings are the trail user conflict workshops, which are held out on a trail. And this is where hikers, bicyclists, and equestrians come face to face and learn of each other's concerns and their impacts on one another. And I got to say, the highlight of these workshops is when the bicyclists get on the horses and the horse riders get on the bikes, and they go down a trail and they really experience what's going on with the other, and it really leads to a lot of understanding. And I think when we leave that area, there's a new appreciation for the needs and concerns of the other group. So we've done that many times at places where we've had our meeting. I'd like to give an example of how a nonprofit, the McCullummy Coast to Crest Trail, was helped by the CRTC. At the last California Trails and Greenways Conference, I met and got to know Mary Boblet, a board member of the McCullummy Coast to Crest Trail Council. Now, she knew that I'm a CRTC member and a resident local to Mount Diablo State Park. So she told me of her difficulty in getting her trail signed through Mount Diablo State Park. The McCullummy Coast to Crest Trail is currently under development, and when completed will stretch from the High Sierra across the Central Valley all the way down to the ocean. So I was invited to one of their board meetings in Stockton and learned exactly what they needed to accomplish. And through my contacts, both at the state park and another nonprofit, we were able to work out a plan for getting the directional signs installed, and it's now being implemented. This is how trail problems can be solved under the current arrangement.
Thank you. I have some questions for you, and we had a Democratic caucus called for shortly, so we're going to end up having to leave, so I'm unfortunately going to speed you up a little bit.
I'll just depart from this.
Okay.
And just in a nutshell, tell you what the solution is to this in our view.
Thank you.
We believe that that the committee takes up a very, very small, it's 1/10,000th of the state park's budget, very small amount. And we don't see that the committee needs to be abolished at this time, that it's possible for it to go on hiatus or some kind of suspension during the period of the budget crisis, of the funding crisis. And so that we're okay with that, and then it would come back later. We're kind of likening it to closure of a park unit. They're not going to sell off any parks, we know that, so we don't believe that the committee should be sold out.
Okay, let me ask some questions of the department. Do you currently take public comment when you release the plan?
Yes, we do.
And will you still continue to have this public forum every year that was partly created by this committee?
The
California Trails and Greenways Conference?
Yes, we will.
And does that allow public participation?
It does. I think there's an option there to be able to do that, especially if we're working with the recommendation that John has in terms of a hiatus for the committee. We could actually, a lot of that action could occur during that time period of that conference once a year, and the public would have the opportunity to have input into the plan if we are going through an update or a progress report status.
And do you notice both the California Trails and Greenways Conference and the plans opening for public comment? It's like so that the folks that are currently participating in the committee would be getting notice of those things?
We currently do not. We currently notice the public meetings that we have for the committee. We don't notice the conference. The conference is not actually publicly noticed, but if we shift responsibilities, we could.
How difficult would that be, or expensive would it be to notice the California Trails and Greenway Conference?
It wouldn't be significant at all. It would be very easy to do.
Okay, and then I have a question for the chair. Why does it have to be a government entity? Why can't the work that you do happen through an association?
Because we believe that there would be a perception that public access to a staff function would be cut off, and the perception would be that the public's ability to comment on what's going on would be limited.
Okay, now you heard the questions I asked him about public comment and public noticing of the things that are really critical to what you're doing now. If we had a mandate that the department publicly notice and take public comment for both the plan and for the conference, would that address your concerns about making sure there's public access?
I really think it means a lot to have a face on the input to state parks. That there's 7 members who all have a face. We all have our sort of a constituency. I call it our watershed. Where we gather. We have experience with these different groups and these different people. That means a whole lot. And they, like I just gave you that example about the McCollum Coast to Crest Trail. I mean, she wouldn't have gone to Steve's office for help for that, but she came to me, and I was able to help her out because I have contacts and I have experience with the state parks.
I guess where I'm leaning is even if you weren't on the RTC, you still would have been able to help her out.
But she wouldn't have known me, though. It's a visibility that is carried with being a member appointed by the governor that lends a little more standing to it. Otherwise, I'm just another person attending the conference.
Right. I understand. We've also agreed to take. If there's no other questions from members, we've agreed to take public comment on this section of the committee too. Is there anyone here wishing to comment? Thank you.
Thank you. Excuse me. Thank you, Chair and members. Reed Addis on behalf of the San Joaquin River Parkway and Conservation Trust, here to respectfully ask that you reject the staff's position on this. While we've heard the conversation here today, I think there's 2 things I'd like to leave you with. One is that I think these cuts to state parks actually argue that this entity needs to stay alive, trying to subsume their activities around user conflict, which I can guarantee you all of you have had to deal with in your district offices, is greatly dealt by this committee. If you have left staff at the State Parks Department, you won't have the ability to deal with those user conflict and standards there. Secondly, the federal Outdoors Initiative is providing additional planning and funding for the state, in particular for our neck of the woods, the San Joaquin area. There will be funding for parkway trails. We are going to heavily rely on this committee to help us deal with not only the user conflict issues, but the planning and trail system there. So we think this is a very cheap, useful tool, and respectfully would request you vote against the staff recommendation. Thank you.
Thank you. Do you mind if I ask you a question?
Certainly, Chair.
Do you find that the tools that are already available, the toolbox that they have for dealing with the conflicts, the model rules for trails, that those are not helpful enough to you?
No, I think we would argue those are wonderful tools and have been very helpful. I think it's the ongoing activities that I would stress are very useful to us when we're doing our planning activities and addressing user conflict.
Okay, thank you. Anyone else for public comment?
I'm wondering if there's enough time. One of the other committee members was here with me, but she had to leave. She only had a limited number of time, and she had a statement. Would it be possible for me to
Sure,
read this?
Please do.
Okay. So I'm speaking as her. My name is Kathy Hagensmith, and I was appointed to the CRTC in 2008. I am the mountain bicycle representative John has referred to. I have been involved with IMBA, that's the International Mountain Bicycling Association, ever since I started volunteering to work on trails in 1994. IMBA California's platform is 1, to open California trails, 2, promote a statewide approach, 3, improve relations and form alliances, and 4, get riders involved. There are about 60 affiliated clubs, a similar number of bike retailers, and industry supporters, and several bike patrols across the state. As a leading advocate, I regularly engage the trails constituency in stewardship of our state parks' precious resources. I believe a key role as a member of the CRTC. I am proud to be able to work with my fellow committee members to share knowledge, expertise, and resources. I also feel I work well with the agency staff members. In this way, and for very little money, the CRTC can find common ground and have increased communication between state park staff and healthy Californians. I support John's request that the CRTC be placed on hiatus. Thank you.
Thank you very much. And please let her know we did hear her comments.
I will.
Thank you. We're going to have a discussion with the staff on how the report could potentially be modified based on the comments that we heard in the committee hearing today. So you'll be hearing more from us. Okay. Thank you very much. This adjourns the Joint Sunset Review Committee hearing.